SJC-11797, in re adoption of a minor.
Good morning, or good afternoon. May it please the court. My name is Patience Crozier, and I represent the petitioners for adoption. This case is before the court on a reservation and report from the Middlesex Probate and Family Court. Petitioners are a married couple who, through assisted reproductions, conceived their son. They filed the co-parent adoption petition not to establish their parentage, but to secure it in light of the inconsistent recognition of same-sex marriage nationwide and the parental rights that flow from marriage.
So if you, I was just trying to figure it, because this is obviously not a problem in this Commonwealth, if they, right?
Their parentage is secure in this Commonwealth,
right,
which is one of the ironies of notice being required of the donor, because if giving notice to a donor would mean that that donor has an opportunity to contest the adoption, because that's a veto essentially over the adoption. So the irony would be by filing this adoption, they would render their parentage in the Commonwealth less secure, when in fact the goal was not in the Commonwealth, but to secure it nationwide.
So that's what I'm trying to figure out. So now they moved to a state, I'm not sure what.
Georgia.
Georgia, okay. They moved to Georgia, and so you're saying that the uncle, the donor, could theoretically, without this, go to Georgia and contest or seek parental rights. Is that what the worry is?
Or some state?
That's an interesting question. That's actually not my worry, but let me follow your. Without an adoption, my concern actually is, which is the couple is in the state of Georgia. There's a horrible accident. The birth mother is deceased, and the child has literally no legal parent in the state of Georgia, because Georgia does not recognize their marriage. So that is the flaw that we're trying to correct here, is to ensure that they have a parentage judgment that is given full faith and credit throughout the 50 states.
I see.
Now, does it matter that this is a donor? Let's just, I mean, if it were a heterosexual couple and there was somebody who had a one-night stand, a father, would he be in a different posture from this donor in the absence of any paternity finding or of any involvement with the child?
No, so you're saying a heterosexual couple where the wife has had an extramarital affair.
Okay. Okay.
I just want to, because I think one thing your question raises for me is that number of heterosexual couples in the Commonwealth do use donor sperm to conceive, and in fact rely exclusively on 46V to establish their parentage. And I think the notion that same-sex couples have to notice a donor suggests that donor has some rights, and in fact would make heterosexual couples using known donors.
Heterosexual couples don't have to notice the donor?
Because heterosexual couples do not do adoptions, Your Honor, to secure their parentage, because wherever they go, their marriage is recognized and respected.
I get it. Okay.
So in that situation, we would in fact be creating chaos for those many heterosexual couples that do not do adoptions. They just rely on the statute, in the plain language of the statute, which was to secure the parentage in that husband who consented to the assisted reproduction. But did the court want me to address if the wife had an extramarital affair, or?
It's the same thing, isn't it?
It is. In fact, the person that's a putative father under the CC versus AB line of cases would have no right under the paternity statutes or at law to assert parentage over that intact, healthy marital family.
Right. So the source of the sperm does not matter in the absence of a finding of paternity or in the absence of some involvement with the child.
I think the question here is, there would have to be some evidence of clear and convincing evidence, in fact, of a substantial parent-child relationship for someone who, in that case, probably wouldn't be a donor to even get past the door. Then, in fact, it's quite a high bar to assert parentage of a child born into a marriage.
Now, if this, okay, and I guess that's my question. If you had a donor who, by agreement of the parents, wished to be very much a part of the child's life, would it matter? if,
Would
based on
what
what you're
matter?
asking us to do today? Would it have any
No,
consequence
in
on
fact,
that?
from my perspective, the adoption is neutral to the donor. The donor doesn't have parental rights prior to the adoption. The donor doesn't have legal rights after the adoption. What theoretically, any person, donor or otherwise, has the ability to raise some equitable claim to a child based on clear and convincing evidence of a substantial parent-child relationship. So the adoption, in fact, is neutral in that regard.
So the only person that would be entitled to notice under the statute is the birth mother?
For a non-marital child. In this case, the people who must consent to the adoption are the petitioners because they are the child's sole lawful parents. So they have both consented by filing this joint petition, and so the consent requirement has been satisfied.
Okay.
And there's, and I should know this, but was any notice, is there any notice requirement for the donor in the adoption proceeding?
No, that's the heart of this case. This trial court said, reported up the question of whether we need to provide notice to the donor. And
No, but I mean, it's
petitioners-
not by statute or anything.
Oh, no, Your Honor. Under the statute for a marital child, that's addressed under 210 Section 2, and it says the lawful parents must consent. And if the lawful parents do not consent, then they would get notice. But here, the lawful parents consented. It answers the question.
Depending on what the U.S. Supreme Court does on July 1st or before, if they decide that there is a fundamental right, this issue essentially goes away?
No, I think it's really critical for this court to resolve the issue because even with nationwide marriage equality, the implementation of that marriage equality will still be there will be vulnerability for children in other states. For instance, in Massachusetts, it took until 2012 for the court to apply 46(4)(b) in the context of same-sex marriage in the Hunter versus Rose case. So, in fact, there will be, cases. There will be a debate whether that presumption in some of those other states will apply the presumption of marriage. Additionally, I think that goes to the issue of the different sex couples who do use donor sperm. If there is some suggestion that a donor retains some kind of parental right for people who use assisted reproduction, we really very much need the court's guidance on that. That's what we're essentially seeking is guidance to the trial court of how 46(4)(b) really plays out in the adoption context to clarify that the donor retains no rights. In my adoption practice, I see many courts struggling with this issue. One case where the petitioners were a married same-sex couple and there was an anonymous donor, and the trial court rejected our adoption petition saying we had to list the anonymous donor as the parent on the face of petition, giving the anonymous donor the ability to contest the adoption, contest whether the petitioners were married, contest whether there was consent to the insemination.
Even though if it were a heterosexual couple using assisted reproduction, it wouldn't be the same? Or did the judge say that the judge would do the same in that situation?
Well, the judge didn't address that question. The appeals court on an interlocutory appeal did tell the judge that informed the probate and family court to move forward without any notice in that situation. But I think it just speaks to the need for this court to provide clarity and guidance on this issue.
All right, thank you.
Thank you. I'm going to rest on my brief. I appreciate your time. Thank you.